So I want to comment in this video about the Ninth Circuit Court of Appeals ruling against the right to carry arms either openly or concealed in public. But before I get there, make sure you're subscribed, and if you aren't subscribed, do so now, and then hit the little bell icon and make sure that you're getting notifications for when I go live or when I release a new premiere. A friend of mine contacted me today and said, I haven't seen anything from you for a while. So guess what? Looks like YouTube is shadow banning me, and I just hit 450 subscribers. Technically speaking, there's probably more, but I think they keep dropping people and hiding my stuff in their algorithm. So, speak truth, that's what happens. So anyway, back to the Ninth Circuit Court of Appeals. Ladies and gentlemen, the Ninth Circuit Court of Appeals has lost its ever-loving mind. They have no idea at all what they're talking about. In their ruling, in this case coming out of Hawaii, they've stated that your right to keep and bear arms only goes so far as hearth and home and its defense. I don't know that the justices who made this ruling in the Ninth Circuit Court of Appeals really have studied the history of the United States or the Constitution. Because quite frankly, no person who has studied the Constitution, no person that's studied the history of the United States would ever walk away from the Second Amendment and think that somehow the Founding Fathers only intended for us to be able to protect our houses from who? Who are we supposed to protect our houses from? Criminals? Because if you shoot a criminal who's coming in and threatening you, in almost any state, that's going to get you arrested. Now, you might get away later on, but more than likely, you're going to get arrested. Because in states like Minnesota, you have a duty to retreat. So, now granted, the Ninth Circuit Court of Appeals doesn't have say over what happens in the state of Minnesota, but the Ninth Circuit Court does tend to set some precedents, and I hate that in the reality that no court should be setting a precedence like that. But in the state of Minnesota, you have a duty to retreat. In the state of Illinois, you're lucky if you can even own a firearm for self-defense. In Chicago, good luck, right? So what? Just what exactly does it mean to defend hearth and home? And here's what we've forgotten. Hearth and home isn't to be protected just from people who want to come in and steal your stuff and people who want to come in and do harm to you and your loved ones. No, you should be able to defend yourselves from somebody who's coming in to kill you or rape you or in any way harass you or molest you in a violent way. But hearth and home. Really? Ninth Circuit Court? So if someone comes in and they want to steal valuables from me, having a gun means I can use it on them? Because most courts would say no. Most prosecutors would say no. That doesn't count. No, the Second Amendment exists for the same reason that the First Amendment exists. The Second Amendment exists to resist tyranny and to resist foreign invaders or people that are enemies of the state, enemies of the Constitution. Now, I'm not advocating for violence here. I'm not advocating for armed revolt. That's not what I'm saying. But our forefathers, men who were far wiser than any person on the Ninth Circuit Court of Appeals, and quite frankly, men who are wiser than anybody holding elected office today, men who are wiser than anybody serving in any legal capacity today, men who are wiser than anybody who sits on the Supreme Court today. These men, they recognized that in a place like the United States, the grand republic that it is, at some point it may become necessary for the American people, we the people, to rise up and throw off the chains of tyranny. None other than Thomas Jefferson himself said that the tree of liberty must have its roots refreshed from time to time with the blood of tyrants and patriots. That's why the Second Amendment exists. It doesn't exist to protect hearth and home, not in the way that the Supreme Court is ruling it, or excuse me, the Ninth Circuit Court is talking about it. It exists so that our elected servants, who get a little bit too big for their britches from time to time, recognize that the most important thing that they can do is remember their place. Because an armed populace is a protected populace, and they're not protected from criminals. They are, but mostly they're protected from those who would threaten them with slavery and tyranny. That's why the Second Amendment exists. And the Ninth Circuit Court of Appeals got this one wrong, dead wrong. And I hope that constitutionally loyal, patriotic, freedom-loving, republic-serving constitutionalists challenge this in the courts and force the Supreme Court to take this up and to rule the way that our set in stone Constitution is not a living, breathing document. It is a set in stone with one intent document. If the Supreme Court does what it's supposed to do, and it does not legislate from the bench, and doesn't interpret based on current cultural norms, but interprets based on the intent of the Founding Fathers, which was for the people to be able to resist tyranny and throw off the chains of slavery and oppression, then the Supreme Court will overturn the Ninth Circuit Court and rule in favor of the individual who took the state of Hawaii to task. Ladies and gentlemen, this is why the patriotic movement has to exist today. Ladies and gentlemen, this is why we, the people, have got to stand up and start fighting back. Because despots in robes and despots in elected servants' positions believe they know better for us than we know based on what we get from the Constitution. We have got to fight this stuff off. We are losing this country as they shred our Constitution in front of our faces and then laugh at us and dare us to speak out. It's time for patriots to get angry and start demanding that justice and constitutional law be followed once again. Share this around, and until next time, Sic Semper Tyrannis.